Hi there, welcome back. It's the Realtor Lady, Michele Replogle, and today I have a special guest, Roxanne Olson of Fine Point Law, and I found Roxanne in the newspaper. You know, that paper thing you get delivered to your house, which I still love, even though it's very expensive. I love it. And there was a little ad, and her ad said trust equals love, and I love that. I'm not an attorney, so I wanted to get a professional on to go over some of this for you to help you understand what a trust is, what it does, why it's important. And we will then end up with will versus trust. Like, why would you want to do one or the other? And I'm going to turn it over to Roxanne, and you feel free to tell us a little bit about yourself and then move right into what a trust is. And we'll go from there. Welcome.
Thank you. Thanks so much for having me. Yeah, I'm glad that we're talking about this. It's a really important topic. So many people, I would say, I don't know the exact numbers, but I've heard it's in the 60s and 70% of people don't have any kind of planning done. Very high. So it's really
Many way too high.
Yeah, many people that have planning, it's out of date and they haven't looked at it again. I always recommend at least every 3 years you look at it to see if your assets have changed, if the people you named have changed, if they died, have they moved away, and if the law has changed. Because we're writing legal documents and the law changes. So my background is that I did very well academically. I was, second in my class high school. I was Phi Beta Kappa undergrad. I was magna cum laude, top 7% of my law school class. And when you do that well, you get kind of shoved into the top tier of the legal profession, really, which is going to court and fighting it out for your clients. And I had gone to law school because I wanted to help people. This was my idea. I want to be part of the community, be a help. And I found that the litigation process took so long. It was so expensive. There was, a basic conflict of interest in that I was being paid by the minute. And so the incentive to settle is not there necessarily for the lawyer, being paid by the minute, billable hour requirements by the law firm. And I just saw that even when my clients were winning, they were losing in terms of heartache and time. And the other thing is that, you start off fighting for something real, like money, and pretty soon you're fighting for motions to quash subpoenas. You're having 10 more things to fight about. And when it's a relationship like a siblings who need to ideally continue their relationship, even after that lawsuit, it can just destroy the relationship. I decided that I wanted to actually use my, a thing of what am I doing to improve the world for my child here, right? How am I making the world a better place? I have blessed with these skills, and I decided that what I wanted to do was get into preventative law, keep families out of court, out of conflict. And that's, fairly soon after that, I opened up my own law firm. And I decided to focus on this preventative law idea. And I got into estate planning from that perspective. We're not just creating documents for people. We are helping families stay out of court. And with that perspective, but it took a few years before I really realized that the way that they taught us to do estate planning, and estate planning, by the way, is the will, the trust, the power of attorney, just all of those basic things. A lot of people think it's only for rich people because of the word estate, but it's for everybody. It just means a document. So the way they teach you in law school to do it is like a one-off transaction. You go into the lawyer, you say, I want a will or I want a trust. They write it all out for you. You sign, you go home, you put it on a shelf, you check the box, and you think you're done. And there's no follow-up from that lawyer. There's no ongoing relationship necessarily. It was you paid and now you're on your own. What happens is that those documents go out of date. As I was saying earlier, they go out of date with your assets. People buy a house, they sell a house. They go out of date with the people you've named. People will name ex-husbands or their best friend who has now died or moved to Europe. And then they go out of date with the law. Tax law changes all the time, especially when you've got we just had that big Prop 19 tax law change to property taxes, which I'm sure has really affected your work in real estate. And when the law changes, those documents need to be re-looked at. So I implemented a free 3-year review for any client that I work with. And then also an annual review for people that have a lot going on, people who are real estate investors and they're buying, they're selling, that sort of thing. We do an annual review or we do a 3-year review. Just a quick check-in. Doesn't have to be a big thing. But what I don't want is that ticking time bomb on the shelf where you think you have something and you don't. And what we're seeing now, because the baby boomers are aging to the point where they, with incapacity and death, we're seeing a surge of people who got their trusts done years ago. And because a trust is like a garage and it only protects what's in it, we are having to go to court anyway because they have trusts, but they don't have all their assets in the trust. And so we're seeing just this surge of having to tell families, sorry, we know mom and dad paid thousands of dollars, but we still have to go to court because there's all these assets outside of the trust. So I think making sure that there's a trusted advisor relationship long-term with the family. And the other thing that I had to do as a sort of my own shift around that was I had to give up law office of Roxanne Olson, even though I loved it and it made my ego feel good, and become Fine Point Law and hire another attorney and become a larger firm, because I need something that my clients can have as a trusted advisor throughout their lives.
I'm going to be calling you for an appointment already. I'm sold.
So let's start with I love that. That's actually the overarching idea of what trusts do, basically keep you out of court. But what does the actual document itself does? And that might be a little complicated. So whatever simple version you have to help people understand. Because you are right about people thinking it's only for rich people. And I do sit across from people who are buying homes and I say, okay, now it's time to get a trust. And I never really have a good why for them. I just know that they should.
Yeah.
And I don't have we're at a busy place, just a quick snippet of why it's important. So it might be good to start where it is and then why maybe a simple why, if there is.
Yeah, I think a simple why is, and I like to use the image of the little red wagon, those radio flyer wagons. So right now, if you're walking down the path of life and you are holding all of your assets in your hands, you own them. The bank account has your name on it, and then you stumble and fall. Things are going to roll in different ways. So the house, because it is going to be worth more than the minimum to not have to go through probate, is going to have to go through a court process called probate. That court process is set up to benefit any possible creditor that you might have, anyone that you might owe money to. So they purposely make it a very slow process, and they purposely make it a public process so that any possible person out in the world that might think you owe money has plenty of notice and opportunity to come into court and make their claims before your family can get at the assets. So a really fast probate where no creditors actually show up and no one's fighting and everything goes as smoothly as it can still takes about a year. And that's when the assets are locked up because you can't get at them unless you ask the judge special permission. It's a whole thing. And there's so many different fees and costs associated with it that it averages to be about 5% of of your total assets. And where a lot of people in California with real estate, which is why it's so great that you're telling your real estate purchase, someone who's purchasing a house about this, is because when they're calculating that percentage of how much you have to pay based on your total assets, they are calculating it on market value. So if you owe $500,000, they're counting it as $1 million house when they're determining how much you have to pay for probate, not on the market value. So what I have seen and what, a lot of lawyers have seen is families having to sell their homes the probate process because they don't have enough liquid assets to pay these large amounts. And I think, you as a realtor are in on this, but a lot of the public doesn't realize that there's a whole industry around showing up to probates and seeing if you can get a cheap house because the families are having to sell them under a fire sale situation to pay the probate fees. So they don't get to make sure that, prep the house, sell it in the best time of year to sell it. They don't get to make those choices. So there's this whole industry around preying on the families who are forced to sell the homes. And it's sad. And people who are seeing, I've heard stories about that. What they're wanting to do is set up a trust. So a trust is a private document that can be administered in the privacy of the lawyer's house. Nobody in the public gets to have access to seeing the trust. Unlike over in probate, when it's a public thing and everybody gets to know who's inheriting what and exactly all, where the money's flowing and all of that, and gets to offer people one-time opportunities that they just aren't going to be able to turn down if they just got an inheritance or, offered to buy the house. And but a trust, I think a common misunderstanding is that a trust is something that isn't going to cost any money at the end or not need any administration. It does need some administration. There will be some costs at death, but it's all in the privacy of the lawyer's office and not public in the court, and it can go much quicker.
I think you just said the lottery word or the money word for people is privacy.
Yeah.
I think that's really it, because I have worked with families that have really wanted to make sure nobody knew what was going on in their family and friends. And some of them had trusts and some of them didn't. And the ones that didn't, it became everybody knew what was going on.
That when you've got maybe a young person inheriting a larger amount of money and it's in the public knowledge, there is an industry around trying to give them opportunities to part with their money.
Wow.
Yeah.
I did not know that. Wow.
Because it's public.
So it's basically a document that would spell out what is to happen when the trustees pass away, or what would be the
back to my radio,
kind of like a map, right? Or
Yes. And like I was saying with the radio flyer, so if you've got your little red wagon and that's your trust and you have everything in it, then you're walking down the path of life and you stumble and you've got someone set up to just take your same wagon with all your stuff down the plan that you have. So the idea is that a trust is going to have a plan and it's to this other person, or I'm giving my assets to this charity, but if it doesn't exist anymore, then it goes to charities of similar type. So it has all these contingencies built in. And what I do, because the trusts are written in legalese, you want them to be understood by lawyers and judges if they ever have to be argued in court. But I always create a full, it's like a full fold out map, just exactly how you're saying, map showing the trust.
wow.
And that's something else that I have started doing as I realized that, a trust only works if the clients really understand what the plan is. They can't stay on the plan if they don't get it. So I put a lot of energy into educating. I actually bring everybody in for an education meeting first. Before they even hire me, I bring them in for what I call legacy planning session, where I'm educating them, because I really, whether they end up hiring me or going out and hiring somebody else, they need to understand what it is that their plan is, or they won't stay on it.
So I just had an epiphany when you said that, have everybody in. I'm going to use myself as an example, but families would be better served really taking the person with them that they want to take over, which would be our son, our adult son, actually attending a meeting and having an idea of what goes on. Because I envision him having something happen to one or both of us and him looking at this binder and going, okay, what does this mean? Yeah. They're in the hospital. They're incapacitated. I believe we have a medical directive, but I don't know, maybe it's not written right. But anyway, I just imagine him sitting there with this binder going, okay, what page, what do I do with this? Now I have these people with these assets, and
there's quite a lot of very well-meaning, I don't know if this is sexist to say, but I'm just saying, like, the very well-meaning eldest son type person who, and it can be an eldest daughter too, who gets saddled with that and doesn't know what to do and doesn't know who to reach out to and attempts to do everything themselves and then can fall into some really easy potholes. One of the things that you're probably aware of in real estate is that parent-child exemption, where you can pass your low real estate taxes to your child, is not automatic. It requires applying for it. And you have to apply for it pretty quickly within 3 years. And what I get in my office is, the eldest child who was assigned to be the trustee, the successor trustee, they take over. They didn't really know what they were doing. And now they've got this huge, big tax bill because the assessor's allowed to take 5 years before they get around to it. And then they send you that nice fat back tax bill. And by then your chance to apply for the exemption has expired. So there's a lot of little potholes that happen. So the thing that I do is, and because I'm seeing this, so I actually do reach out to the successor trustees right away. I do what I call my inner circle program. So it's not just the trustees, but it's all the people that you've named as part of your inner circle. And we reach out and we let them know. We don't give them the terms of the documents because you're allowed to change the documents. We don't let people get too attached. But we let them know that they've been named and that they could, reach out to you and ask you where it's located, because that's a thing that comes up, right? Where is that? Where's that will? And then the other thing I do is, so I'm connected with them. And then in the binder, like I said, I do a full fold out, multicolor spreadsheet of exactly what's going on. I also do a paragraph by paragraph layperson translation of the trust document so that they have that. And then I have a whole cover page that says letter to the successor trustee. These are the steps. And I highly recommend that anybody who's named as a successor trustee does go in for at least a educational appointment with a lawyer to understand what the roadmap is, because like I said, there are lots of potholes and they can be very expensive.
I think, and the part we're not really touching on, which is so important, and this is where I usually come in, is where I have a grieving family member and they can't actually cope with finding somebody to, they know they have a copy of it. And quite a few of them understand it and know what their role is. But some of them are grief stricken and they cannot cope with dealing with it. And then they don't understand it. And so I get in this position where I'm selling their house and I have the title company explaining it to them, because they're just so overwhelmed. We can't get them to go hire an attorney or find the attorney. Luckily for me, I've been able to convince them midway to find either their family attorney or an attorney, midway. But there's that emotional factor that we get into why the trust is so important too, because that roadmap is there for them because they may not be emotionally ready to deal with some of the stuff that's going to come at them. At least they have this plan, or this is how it should go.
I have a lot of free resources on my website at Fine Point Law, and one of them is Successor Trustee Handbook, which I put out there for the, just for the people, because I want at least the basics to be available for everybody. And the other thing that I do is for the administration clients, I charge a fee for them to come, but then I apply that fee to any work that they may want to hire me for later. And so just with the idea that trying to encourage people to at least get educated, at least go to the initial education meeting and get their own roadmap set up. It's a big thing that I say. So I'm a parent and I really relate to this idea of don't leave a mess. You're in the kitchen, you clean up before you leave. Don't leave a mess. And that's a big reason what you're saying is we don't want to leave a mess for people that are grieving. When you've done a comprehensive plan, you have set things up to be as simple and straightforward as possible. And another big layer that we haven't gotten to that I think is critical is a more base layer, even under all the documents, and that is organization. Organizing your financial closet. People have so many different assets these days. They go online and they open some bank account, some, E-Trade type of account online, or they go buy some Bitcoin, or they go to they switch banks and go to a new bank, or they get a job and have a 401k, and then they leave that job and it rolls over to an IRA somewhere, and they end up with a mess of different stuff at different ends. And most people don't have one place where they have organized everything and also kept track of how it's owned. Is this owned? Is this in the trust? Like I said, trust is a garage. It only protects what's in it. Is this account owned by the trust? Is this, life insurance policy set up to pay into a trust? Just going through. So what I do with my clients is I do a base layer of organization. And I've worked for years on creating a spreadsheet that I love for this, of making sure that we know where everything is, what everything is, and how it's owned. And also whether it's community or separate property, because California is a community property state. And another big reason for that is because if your child, your son who's trying to take over doesn't know every single thing, things get lost. We just hit $10 billion in the California State Department of Unclaimed Property. That's just lost assets in California because, most of the time it's because someone became incapacitated or died, and they were the person in the family that knew where everything was. And the other, often in a relationship, in a marriage or in a family, there's one person who's kind of keeping mental track of it all. And just the way our society is treated, there isn't somebody that usually helps people put everything on a spreadsheet and keep organized. Lots of times your financial advisor is only doing things that they're managing, and your lawyer's only doing the real estate. So I've decided that as an estate planning attorney that wants to be holistic and thorough, that's my first step with everybody. And even before we're choosing between a will or a trust-based plan.
I also heard another few points in there too. Sometimes there's a couple other things. Our society, we're taught not to talk about our wealth, and that's considered showing off, even maybe in a more formal relationship with your children, of kind of really trying to maybe explain your assets in a way like, well, this is how we got to take care of them. But you don't want to overarch how much you might have. Maybe your adult children, you might feel like they would want to get at those assets before you pass away. So there's that piece of that. The other part of it, unfortunately, I think is still very prevalent is sexism, where there is a patriarch that does not want everybody else to know or feel that they're fit and able to understand these assets that they have, or they're going to take care of them. And then the last one is mortality. And what I run into more is people, I feel like when I'm talking to older people, I feel like I am touching on them dying someday, and they don't want to talk about that. And I don't see it that way. I see it like you have it as organizing in place. It's just like one other thing. It's like organizing your garage. You're just organizing your finances. But there's a lot of other things that come and attach to that. That's unfortunate. That's just really unfortunate. I think that's part of my year-long pushing at this, is maybe trying to bust through that and help people understand through education of, no, that's really not that. It's just being really prepared and making things easier for the people who come across it later on. I did a few last year that were fairly straightforward, but it would have been better if they were trusts and not wills. The wills made it definitely more complicated, and there was more people involved, and the beneficiaries were not happy, and they didn't think that person should have been in charge of everything. So there was some uncomfortableness that came out of that. But tell us about why wills really aren't ideal. In my opinion, they aren't. Maybe you can bust that myth for me too, and talk about wills versus trusts.
Yeah. So a will is instructions to a judge in a probate. So sometimes people think, oh, a will is also a private document, but it's not. So a will is, you lodge it with the court when you do a probate, and it gives the judges instructions. This, by the way, is much better than having no will, because if you have no will, then the judge just has to make decisions based on the law. So your assets go to, where it's supposed to go according to the law as default. It may not be at all what you wanted. And if you've left a minor child, the judge just has to, the judge doesn't know you, doesn't know the child, doesn't know your family, and they just have to make a decision. And so, and it may be good or it may not be good. But if you have a will, you've left instructions where you want your assets to go, who you want caring for your child. It's much better than not having a will. The thing is that it doesn't avoid probate, it doesn't avoid court, and it is a public document. Anybody can read it. Sometimes when I'm giving these talks, I'll bring up the will of Jackie Kennedy Onassis or, some other famous person. And I'll say, look, you can see, who they loved and how much money everybody got, because it's right there on the will. These are public documents. And
You never did a trust?
there may have also been a trust, but there was definitely a will that got publicly probated. Yeah, there it was. And we can all see it. You can just Google it and pull it up if you want. And
I always thought of her as very organized and very...
Yeah. Well, she was organized enough to have a will, for sure. And there's quite a lot of people that aren't, that don't have a will. And so that's the decision. One of the decisions you're trying to make when you are trying to decide, do I want a will-based plan or do I want a trust-based plan? A will-based plan is going to go through the public court system. It's probably going to cost quite a lot of money going through the public court system if you have a lot of assets. if you don't have a lot of assets, and especially if you don't own any real estate, there is right now, they change it every year, but it's right around 160,000. So if your total assets are less than 160,000, we can do a shorter process. But I will say, we also do a shorter process when it's called a spousal probate, when you're just transferring property from one spouse to the other. And to give you an example of what shorter means in the court system, I helped a wife recently get the second half of the home she owned with her husband. It still took about 4 months before we were able to get it processed through the court system. So that's the quick short one of the only thing was just the second half of her own home. So frustrating, but it's a slow process.
So there's better privacy with a trust. It will be quicker, it'll be more streamlined, and it will be easier on the heirs to manage.
Yes, not just better privacy. There's absolute privacy with trusts. Trusts are private documents, and there's it's absolutely public when you go will. There's no privacy whatsoever. It's purposely public. They're going to have to put a notice in the newspaper with the probate and the will. So on a trust, it's a private document. Nobody ever knows about it.
That's fascinating. I don't think people understand that. And they've passed away, so they're not going to tell their neighbor not to do it. There's their name and all their information in the paper telling who, because I've had it happen where I have my client, everybody is all laid out and who's on the will, and then his name would be there. Well, all the family members are watching all this go on too, and they might feel that they have a piece, so they might be coming after them as well. I mean, that now it's just out on display, especially for larger families. That could be a problem. If they're not part of that will and they really aren't entitled to anything, but they could see that, they might feel they are entitled.
Yeah, for increasing conflict, I feel like the court process, like I said, even when it goes smoothly, it goes slowly and it's expensive. And so there's a loss of money to the family just that way. So it could just increase the tension, and any little conflict between the family can really boil up during a slow, expensive process. While, in the private sphere, over in the trust, when we're administering a trust, and if we can see some families start to boil up, we go right in. I love bringing in a mediator, to help just really smooth that out. And I also, like I said, spend a lot of time educating everybody. I think that's so important. Sometimes it's just a little education, but also the fact that we're not in a court process at all, I think calms everybody down. just having that. It can go much faster. People get their inheritance much faster. And that's another reason I would say to have a lawyer assist you to administer the trust, because there are required notices that need to go out. And where I see conflict come up over on the trust side is because it's private, and sometimes these children successor trustees don't have a lawyer advising them. They may not be giving all of the required notices to the other heirs. And if they're not doing that, then the other heir says, they don't understand why it's taking so long to get their money, and they start not, losing their trust. So when you're working with a lawyer, we're definitely clear with you on what your required notices are, what your required accountings are, and we make sure we get ahead of that so that all of the other siblings understand what the process is and are getting their proper notices, so that they don't start, questioning what's going on.
Well, you're not a one and done. We'll walk you through the process. I think now I'm worried about you retiring now. I met so many trust attorneys that I'm like, they're just one and done. Mine was he built our trust and then he retired, and then we've interviewed a few after that. And honestly, I can say I did not think that they were for us, and I didn't feel like they had our best interests in mind. So I hope you have some plans for retiring, that you have people replacing you to keep walking them through this great process.
Thank you. Yeah, it is. I feel like it's a dirty secret in our industry. If you are in for example, the Santa Cruz Bar Association, and you're getting their emails almost once a month, we get emails saying, so-and-so is looking for their mom's trust. This, the lawyer retired or, died, and nobody knows where it is. Did anyone, get his files when he left? That happens very frequently. It's going to increase even more, like I said, as the large population of baby boomers age. And it was something that I really had to face. I felt like I had to face it because I saw that, and I saw that I'm having my clients face their own possible of incapacity or death every day. So I need to also think about that for myself, really, to be congruent. And that's, like I said, when I switched from Law Office of Roxanne Olson to Fine Point Law, because it can't just be about my ego and what's the name on the door. It has to be something for the clients to be able to rely on. And I was really lucky. I got an associate attorney who was right out of law school, so I got to train her the right way. Brenna Darcy. She's since grown to be a junior partner. She's been with me about 4 years now. And I also tend to hire, I always have interns that are from law school, and I tend to hire people who all of the women who work for me right now are considering going to law school. So I am really trying to have a future for my clients, because I don't want that. And it's so common.
I took a class on probate and trust through the California Association of Realtors, and I loved it so much. I told my husband, I was like, oh, maybe I'll go to law school. He's like, no, I'm always into projects. I always love to learn and do new things. He's like, no. You just stick with what you're doing. But I'm a fan of it because I think it's super important, and I love learning about it. And this has just been so helpful. I want to add in one more thing about the wills too that might get lost, is that because the will may take so long through probate, you may actually lose market value. And I am starting to see that because our market is shifting. We don't see a huge drop in values, but trust may allow you to go grab that market that you feel is advantageous to the estate, where the will may have you wait. And you might actually find yourself in a legal position to sell it at really an inopportune time too. So that's kind of important for people to understand too. It really takes away a lot of the autonomy of the estate to take advantage of market forces or maybe some other possibility that would work better for the estate.
Yeah, exactly. That's what I say about the fire sale. Sometimes you have to just sell, or you can't sell, and
right.
You don't get to have all of those choices. You have to get things approved through a judge, and you can't even get in front of the judge to ask him for another 9 weeks by the time they get you in for a hearing.
Right. Yeah, it's interesting what we learned from just actually, not an attorney, but what I've learned just kind of being out in the trenches and that I've just kind of learned the hard way, really, along with families. So that's my intention, to make things easier for people and their families.
Really great. I would say one other area where you could help your clients, if they're confused about how they should be owning property, whether they should be owning it, especially married couples, should we own this as community property or as joint tenants? Make sure that they give me a call, just a 15-minute call, just to understand the differences between those things.
Okay.
Because it is a very big difference. And way too many families come in, and I see they're set up in a pretty poor tax position. Their family's going to pay more in taxes, or they're going to have to pay more in taxes because of the way they are owning title. So oftentimes that just kind of gets decided off the cuff, at the escrow or something. And it's actually a really important decision.
It is. And for the longest time before gay marriage was legal, it was very stressful for me when I had families buying houses together, and I was concerned how their assets were being protected, in my opinion, from family members that I didn't think had their best interests in mind. So some of the laws that have come along have made it a little less stressful for me. If I couldn't get them to go to an attorney, at least talk to someone else to get them some advice so they could, again, just the vesting even, just to get that proper so their assets were protected if something should happen to their partner. Well, I really, really thank you for being on. This was so amazing. There's so much to think about, but I think my big takeaway for the will is privacy. And I think that's what people really, really value over so many other things. Even maybe the assets themselves is really just privacy for them and their family. I never knew that aspect of that. So if nothing else, if somebody listened to this and they came away with that big takeaway about why you should get a trust, that's it. And I'm so excited because that's why I wanted to have you on. I knew I was going to learn something big. So this is really, really cool. I'm hoping maybe you can come on again in a few months and we'll find some other topic that's so important for people to learn. But this is a great starter pod for people to get their heads wrapped around their assets and how to protect them.
Wonderful. Thank you for having me.
So how do people find you or your law firm?
Yeah, we are at www.finepointlaw.com. And like I said, we have a lot of free resources on there. So it's worth just going and take advantage, download whatever you want. I also have a 45-minute webinar that you can watch, and I try to make it funny so it's not so sad and terrible to think about your own death. But I do offer that, and you can just watch that whenever you want and learn about the different types of documents you might need, like a will, trust, powers of attorney, all of that, guardianship nomination. And my email is hello@finepointlaw.com, and phone number is 831-471-5293. We offer free 15-minute calls. You can go right online and book one and see if we're a fit for you.
Well, I'm going to. I'm excited.
Okay.
Well, thank you again.
Thank